Hi, I'm Jeff Cooper with Century Law, Wealth, and Tax. And if you're wondering whether or not you need to update your estate plan, then in 5 minutes or less, I'm going to give you a self-assessment checklist that will let you figure out whether or not you should schedule an appointment with an attorney to update your estate plan. So let's get right to it. 5 minutes or less, a checklist on how to tell should you need to update your will or power of attorney or your trust. So I'm going to refer to my handy dandy notes here. And so step number one of four, is how to figure out if your documents are out of date, too old, and need to be updated. One of the most common misconceptions that I hear is that folks tell me, well, my power of attorney, my will is 10 years old, and so it must be out of date, right? Wrong. Wills, trust, and powers of attorney don't have an expiration date, which means they might be 5 years old, they might be 10 years old or older, and still represent your wishes adequately. So just because they're old does not mean that they need to be updated, but some of the following considerations or issues might mean that they need to be updated. So here's some of the issues that you should be considering. Number one, have you moved or crossed state lines, or have your assets changed significantly since your last documents were created? If so, you should consider updating your will or trust. Number two, was your will or trust created prior to 2005 when Congress made a very major change to the tax law? So that would be if your will or trust are older than 15 years old, okay? And that change allowed husbands and wives to add their tax exemptions together. So if your plan is older than 2005, consider updating your plan. Have individuals in your documents passed away? Ought to consider updating your plan. Have new individuals been born since you last put your plan in place, like grandchildren? If so, and you want to leave something to them, then you might consider updating your plan. Was your power of attorney created prior to 2018 when North Carolina passed massive changes to the power of attorney law? And has your lawyer or the law firm that drafted your documents essentially forgotten about you and not kept you up to date, not sent you emails or given you opportunities to connect with them over the years since they did their work to keep you abreast of changes in the law? If your lawyer or law firm has not kept you up to date or given you opportunities to stay up to date, then you should consider switching. Does your plan include provisions about 401ks, IRAs, or other tax-deferred assets? If so, the Secure Act made major changes to how those types of assets get passed down to beneficiaries, whether your children or other beneficiaries. And so if your plan or if your assets include IRAs, 401ks, tax-deferred annuities, anything along those lines, you ought to consider updating your plan because it's the Secure Act in 2020. So if you answered yes to any of those questions in step one, you should consider speaking with an attorney to update your plan. Step number two, how to figure out if you have all the right fiduciaries in place. So what's a fiduciary? Fiduciary is a person named in your will, your power of attorney, or your trust, and they go by different names. So it could be your agent, could be your executor, personal representative, or trustee. So all of those together are considered your fiduciaries. And so do you know who each of your fiduciaries are in your power of attorney, will, or trust? And if the answer to that is no, you need to get to looking. Next is, would you feel comfortable giving this fiduciary person full authority over your checking account, your investments, or your real estate? If the answer to that is no, need to be thinking some things through. Do you feel that this person, this fiduciary, is knowledgeable enough to handle the job? Do you feel that they'll have the time to do their job if called upon? Do you know that they'll take care of you or take care of your beneficiaries when the time comes? If you answered no to any of those questions, you need to see an attorney. Moving on to step number three, how to figure out if your assets are protected or not. So, powers of attorney, wills, and most trust are not designed by default to protect your assets in the event that you need long-term care, meaning nursing home or assisted living. So if you need nursing home or assisted living, are you sure that your home and investments are protected from those long-term care costs? If the answer to that is no, you need to be speaking with a professional. Do you know if your home would be protected against claims against your estate made by nursing homes or Medicaid. If you don't know that your home is protected against those types of claims, you need to be talking to somebody. Do you know if your beneficiary designations are aligned with your will or trust? If you don't know that, you need to be talking to somebody. So if you answered no to any of those questions, time to talk to an attorney. Last step number 4. How to figure out if your beneficiaries are protected. Beneficiaries might be children, they might be nieces and nephews, they might be friends that you're leaving assets behind in your will or trust, or it might be charities like your alma mater or your local church or something along those lines. And so if your beneficiaries are individuals, they might face the following issues. They might have divorce. They might have to pay a bunch of taxes. They might be tempted to spend it all, right? Or they might have creditor claims like back taxes or credit cards, right? And so if you have beneficiaries and you have any concerns about any of those types of situations, divorce, taxation, spendthrift, or claims by creditors, then you need to be talking with an attorney about how to protect those beneficiaries. If your beneficiaries are organizations or charities rather, then you might have a problem if you're leaving behind an asset that's not liquid, kind of like a car or a home. So let's say that I'm going to leave behind a car or a home to my church or to my alma mater. Is that church or that alma mater in a position to be able to take care of your home, hire someone to sell it, get the appropriate amount out of that? Many charities are not in a position to be able to take care of that properly, and so you have to give your fiduciary special authority to be able to sell and liquidate that property and deliver the proceeds to that charity. And so if that's you and you're leaving behind money to charities, make sure that you have special permission in your documents that gives them the authority to do that. So if you don't have that, you need to talk to an attorney. So that we made it through the 4 considerations, the 4 big picture considerations for do you need to update your estate plan, your wills, your powers of attorney, or your trust. And so if these self-assessment steps 1 through 4 have helped you to determine that, yes, I need to see an attorney, then there's very easy ways to get a hold of us here at Century Law, Wealth, and Tax, all right? So 2 ways. You can call the number, 888-364-2949. Again, that's 888-364-2949, or below this video, there's going to be a link straight directly to my calendar. You can click that link and schedule a free 1-hour consultation. So whether you call on the phone or use the link, you can get a free 1-hour consultation if going through this self-assessment checklist has helped you determine that you need some help. So look forward to hearing from you. Take care. Until next time, Jeff Cooper, Century Law, Wealth, and Tax.